Hello, good morning, everyone. Welcome to another episode of the lecture on loan obligation and contracts. In this portion, we are going to discuss about the different modes of extinguishment of obligation. So let me share my screen with you. Okay. Chapter 4, Extinguishment of Obligations, General Provisions. Class, when you say extinguishment of obligation, this means that it is an end to an obligation. So previously we have discussed the different kinds of obligation. But when you say extinguishment of obligation, these are the manners or ways by which an obligation is extinguished or is being ended or terminated. Now, Article 1231. Obligations are extinguished through the following means. 1. By payment or performance. 2. By the loss of the thing due. 3. By the condonation or remission of the debt. 4. By the confusion or merger of the rights of creditor and debtor. 5. By compensation. And 6. By novation. Other causes of extinguishment of obligations, such as annulment, rescission, fulfillment of a resolutory condition, and prescription, are governed elsewhere in this code. Now, aside from these enumerations under Article 1231, you have payment, loss of the same due. I think we have discussed this in the previous lecture. Now, if the thing is determinate and that it was lost without the fault of the debtor through a fortuitous event, then the obligation is extinguished. No? Then condemnation, remission of debt, we will go into details as we go along. And then confusion or merger of the rights of the creditor and debtor in one person. Compensation or set off and novation. Now, these are other additional causes of extinguishment. You have fortuitous event or loss of the thing through a fortuitous event, impossibility of fulfillment. Now, when you say impossibility, this can be legal impossibility or physical impossibility. When you say physical impossibility, the undertaking or the obligation is physically impossible or is incapable of performance through human limitations. On the other hand, when you say legal impossibility, it is prohibited by law. What are examples of physical impossibility? For example, for a man to fly without the aid of technology or any other help from a tool. Okay. Now humans, no, it is impossible for a human to fly. This is a physical limitation. This limitation is dictated by the innate limitations or inabilities of humans. No, so that is physical impossibility. When you say legal impossibility, the performance of the obligation is prohibited by law. No, for example, the selling of illegal drugs or dangerous drugs, which is punishable under the law. No, when you say legal impossibilities, it is also called as what? Outlaw. No, outlaw. Now, resolutory, okay, mutual decision of the party, death of the party requiring personal services, compromise. Okay, you will take note, class, that in if the obligation is subject to a resolutory condition, upon fulfillment of that resolutory condition, the obligation is extinguished because, again, as we have previously discussed in the different kinds of obligation, in a resolutory condition, the obligation is immediately demandable and is terminated only after the happening of the or the fulfillment of the condition. So the fulfillment of a resolutory condition is also an additional cause of extinguishment of the obligation. Also, if both parties wishes to walk away from the contract, both parties agree not to proceed with the contract anymore or not to fulfill their own part of the prestations. It is mutually agreed upon by both parties, then the obligation is likewise extinguished. Take note, class, that the decision must be mutual in nature. One party may not impose upon the other his intention to not perform the obligation. The decision must be mutual between them. And the next, death of a party requiring personal services. If the prestation is a personal obligation and the obligor dies, the obligation is extinguished. Why? Because the obligation is personal to the obligor, meaning the personal qualifications or the qualities or the qualifications or the characteristics, skills personal to a person was taken into consideration upon the establishment of the contract, in which case the death of that person, of that particular person, whose skills, qualifications has been taken into consideration, no, the obligation will be extinguished. Now, compromise. Compromise, when you say compromise, this is the concessions given by both parties. No? Okay. Now, let us go to Chapter 4, Extinguishment of Obligations, Section 1, Payment or Performance. This is the first mode of extinguishment of obligation. Now, under Article 1232, payment means not only the delivery of money, but also the performance in any other manner of an obligation. Now, in ordinary parlance, when you say payment, it means delivery of money. But in legal parlance, payment means delivery of money or the giving of a thing, the doing of an act or not doing of an act. Now, Article 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered as the case may be. Now, you have here under Article 1233 the concept of payment. Number one, class, remember this concept, integrity of prestation. When you say integrity of prestation, this refers to the full performance of the obligation. The obligation must be performed completely or in full. If the thing delivered is not the thing, or if what has been delivered is incomplete under the agreement or what has been stipulated by the parties, then the creditor can refuse to accept the payment. Take note of that. That means integrity of the prestation. When you say integrity of the payment, that means that performance must be in full. Delivery must be complete. Okay. Now, what about identity of the payment? No? When you say identity of the payment, it must be delivered. Not the same object that has been agreed upon by the parties must be delivered. No, the very and agreed prestation must be delivered. That is the concept of identity of payment. Remember this concepts, class. Again, I will repeat. When you say integrity, there must be full payment or complete delivery. When you say identity, that object which has been agreed by the parties must be the same thing that must be that has been delivered. Okay. Now, presentation of receipt is a decent confirmation of payment. In this way, a debtor can request a receipt from the creditor once his obligation is paid. Now, we go to another article, Article 1234. Now, this article is, you're just like counting. Okay, one, two, three, four. Now, if the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Now, class, the most ideal of things is that the obligation is strictly complied with, or that the debtor had completely delivered in accordance with what has been agreed upon. But Article 1234 or Article 1234, no, allows the debtor or obligor to perform a substantial performance in good faith, no, as a substitute for the strict and complete fulfillment of the obligation. Now, the law says, if the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Okay. Now, class, Article 1234 is an exception to Article 1233. While in Article 1233, the law compels the obligor to a complete performance, no? And that the law compels the obligor to deliver the very same thing that has been agreed upon. Article 1234 allows substantial performance, meaning there had been incomplete performance, but the obligation was substantially performed. When you say substantial performance, that means that although incomplete, would be acceptable to the creditor. Now, and will be considered as fulfilled only compensation about breach of the obligor. Now, only compensation about the breach of the obligor must be paid. Okay. Memorize the requisites of substantial performance. Huh? Essential or important part of contract have been performed while the minor details are not performed. No? The doctrine of substantial performance. Now, the obligor must be in good faith. Now, when you say good faith, there is absence of bad faith, or that there is honesty, there is sincerity on the part of the obligor. Now, good faith is presumed in the absence of proof to the contrary. Everyone is presumed to be in good faith. You do not need to prove that the performance was made in good faith, because the presumption of the law, when you say presumption, the law presumes, the law assumes, no, that every performance is done in good faith, and that it is the burden of another to prove that performance was done in bad faith. That is what you mean by presumption in the absence of proof to the contrary. Okay. So first, there must be substantial performance. When you say substantial performance, the important part of the contract have been performed, while the minor details have not been performed, and that there is good faith on the part of the obligor. Now let us go to Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. Okay. Now, class. Under Article 1235, the law compels the obligor to express his protest or objection in case that he accepts the performance knowing it is incomplete, or knowing it is irregular. Otherwise stated, if there was incompleteness or irregularity on the part of the performance of the obligation, then the obligee must interpose his objection or protest. Otherwise, if there was no protest or objection, and the obligee knowingly and intelligently accepts an incomplete or irregular performance, then the law will presume that the obligation is deemed completely or fully complied with. Take note of that. The requisites of Article 1235 is that number one, the obligee knows the incompleteness or irregularity of performance. That is that is very important, class. That the obligee knows about the incompleteness or irregularity of the performance at the time of the acceptance. Because otherwise, if the obligee is unaware of the incompleteness or irregularity, then 1235 will not apply. For example, class, if the defect of the performance is hidden in nature, meaning it is not obvious to the eye of the obligee, then you do not apply 1235. 1235 will apply only if the obligee knows the incompleteness. And second, despite incompleteness, he accepts the performance without expressing a protest or an objection. Okay? Now, let us go to Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Now, question. To whom can the creditor accept payment? In the most ideal of things, it is the debtor who will have to settle the payment to the creditor, correct? Because they are the parties to the obligation. But can the debtor compel the creditor to accept payment or performance by a third person? When you say third person, this means a person other than the contracting parties. Now, this third person has no interest in the fulfillment of the obligation. He is not a guarantor. He is not a surety. Can the debtor compel the creditor? Answer, no, no, no. The creditor is not bound to accept payment or performance by a third person who is not interested or who has no interest in the fulfillment of the obligation unless there is a contrary stipulation. Take note of Article 1236. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. Now, in case a third person will pay the creditor and that the creditor will accept the payment from a third person who has no interest in the fulfillment of the obligation, what is the right acquired by the paying third person? Now, the answer is on the screen. That person who pays for another may demand from the debtor what he has paid. So the law provides that he can recover, he can demand for reimbursement from the debtor what he has paid or the amount that he has paid the creditor. Is there an exception to the general rule? Yes. Except that if the payment is made without the knowledge of the debtor, or even if the debtor has knowledge of such payment, but it was made against his will, he can recover only insofar as the payment has been beneficial to the debtor. In case the debtor does not know about the payment, or if the debtor knows but he objects to the payment of the third person, then the third person can reimburse payment only if the payment has been beneficial to the debtor. In other words, class, under the first clause of Article 1236, and class, this is the first clause. Yan. Whoever pays for another may demand from the debtor what he has paid. This is the general rule. If there was payment, then there is reimbursement. Absolutely. Absolute reimbursement. Exception if the payment is made without the consent or knowledge of the debtor, then there is only beneficial reimbursement. That is what we call beneficial reimbursement. What is beneficial reimbursement? The third person who paid the obligation can only obtain reimbursement if payment has been beneficial to the debt. In other words, if the debtor benefited from the payment of the third person, because payment was made what? Without the knowledge or against the will. Now, let us break down little by little Article 1236. Now, who are the persons from whom the creditor must accept payment? Number one, debtor. Number two, the guarantor. Now, there are third person without interest but with stipulation. Now, if for example, the contract will provide that the creditor is bound to accept payment from a third person who has no interest in the obligation. Can the creditor be compelled to accept the payment? Yes, if there was an agreement between the parties in the first place. So a third person can compel, or the debtor can compel the creditor to accept the payment of a third person who has no interest in the obligation if there was a stipulation in the first place. So take note of this enumeration. The debtor obviously is the person from whom the creditor must accept payment. The guarantor, obviously, and a third person without interest but with stipulation, he is capable of payment. Okay? Now, okay. Now, what are the effects of payment by a third person? If the payment is made by the third person without the knowledge or against the will of the debtor, I will repeat, the payer can recover only insofar as the payment has been beneficial to the debtor. Recovery is only up to the extent of the debt at the time of the payment. On the other hand, if the payment by the third person is done with the knowledge of the debtor, then the third person shall have rights of reimbursement and subrogation of amount that is necessary to extinguish the obligation. Now, class, take note of these differences. I will repeat. If payment is made with knowledge of the debtor, then there are two things that the third person can acquire. Number one, he has an absolute right of reimbursement. And number two, he has a right of subrogation. When you say subrogation, class, the third person is subrogated to the rights of the creditor. When you say subrogation, what do you mean by this? That means that the third person will acquire all the rights of the creditor. That paying third person will step into the shoes of the creditor. And he now assumes the rights of the creditor and he can now demand for reimbursement. That is what you mean by the term subrogation. Okay, let us go to Article 1237. 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from mortgage, guarantee, or penalty. Okay. So Article 1237 provides for a third-party subrogation rights. Whoever pays on behalf of the debtor with consent is entitled to subrogation. If there is no consent from the debtor, then the third person cannot compel the let us go back. Then the third person cannot compel the creditor to subrogate him in his rights. Nakalagay dyan, class, such as those arising from mortgage, guarantee, or penalty. Because, class, if the payment is made with the consent of the debtor, then the third person can acquire all of these things, mortgage, guarantee, or penalty. Okay. Let us go to 1238. Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Okay. What if the third person would like to pay the creditor, but he does not intend to be reimbursed? Meaning to say, he does not seek reimbursement from the debtor. He does not want to be paid back by the debtor. If the payment made by a third person is made without the intention of reimbursement from the debtor, then that payment is considered by law as a donation. Donation. In a contract of donation, if you will read further into the civil code, requires acceptance by the debtor. Without acceptance, there can be no contract of donation, which is why under Article 1238, donation requires consent of the debtor. Before a donation is perfected, the donation must be accepted by the donee. The donee is the recipient of donation. Donor is the giver. Okay. But class under Article 1238, although the debtor may not accept the donation, payment as to him will be valid. No? But the payment is in any case valid as to the creditor who has accepted it. Meaning to say, class, whether or not the debtor accepts the donation, insofar as the creditor is concerned, the payment is valid. Okay? Because of the reason that no one can be compelled to accept the generosity of another. You cannot be compelled to accept the generosity of another. Okay? Now let us go to 1239. In obligations to give, payment made by one who does not have free disposal of the thing due and capacity to alienate it shall not be valid without prejudice to the provisions of 1247 under the title on natural obligations. Now, when you say free disposal of the thing due, this means that the thing to be delivered must not must not be subject to any claim of third persons. When you say free disposal, a third person is not claiming any right or interest over the property. When you say capacity to alienate, that means that the person is not incapacitated to enter into a contract. Capacity to alienate means fitness to enter into a contract. Okay. So take note, klasa, of the difference between subrogation and reimbursement. When you say subrogation, in layman's term, you step into the shoes of another person. You acquire all the rights of the creditor. Now, there is a change in creditor. Now, reimbursement, you are entitled to what? Refund to the extent without guarantees and securities. Okay. Take note, class, that a minor has no power to alienate a property, not a contract. A minor has no power or has no capacity to alienate a property, which is why, class, when we reach the defective contracts, now when we reach voidable contracts, specifically, whenever a minor enters into a contract, the contract is voidable. Why? Because a minor has no capacity to alienate a property. Now, let us go to Article 1240. Payment made to the person in whose favor the obligation has been constituted or his successor in interest or any person authorized to receive it. No? Payment shall be made to the person in whose favor the obligation has been constituted or successor in interest or any person authorized to receive it. So very basic for the persons from whom the payment shall be made, the creditor or obligee, his successor, or the person he authorized. Okay? Okay. Now, let us go to Article 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Now, what if the creditor or the obligee is an incapacitated person or just like a minor? A minor is incapacitated to administer his property. Is the payment valid? It depends. If the minor or the incapacitated person has kept the thing delivered, or insofar as the payment has been beneficial to him, the payment will be valid. In other words, class, payment to a minor has conditions. No, it is the validity of payment to a minor is conditional. What do you mean conditional? It depends if the minor has kept the thing delivered or if the payment has been beneficial to him or if the minor has benefited from the payment. So there is what? A limited or qualified validity of payment to a minor. Now, payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. Now, what about payment made to a third person? Is it valid? Yes, if it has redounded to the benefit of the creditor. Now, in the following instances, benefit to the creditor does not need to be proven. Number one, if after the payment, the third person acquires the creditor's rights. In other words, even if the payment is made to a third person, the right of that person is subsequently acquired by the creditor. So, in other words, the payment made to the third person which reaches to the creditor is ratified. Okay? Because the creditor subsequently acquires the right of the third person. Or it's the other way around, sorry. If the third person acquires the creditor's right, because there is a merger now between the third person and the creditor. Okay. Now, second, if the creditor ratifies payment to the third person. When you say ratification, if after payment, creditors discover the payment and he agrees or he consented or he approves the payment made to the third person. Now, number three, if by the creditor's conduct, the debtor has been led to believe that the third person had authority to receive payment. Now, in the third instance, the debtor was made to believe that this third person had the authority to receive the payment. And so if the payment is made to him, you do not need to prove that the creditor has benefited from the payment. Okay. Now, what are the effects of payment to an incapacitated person? It is valid unless the thing is kept or benefited by the payment. Okay. You can pay to the guardian, or an absence of benefit can result to the obligation not having extinguished, and therefore you have to pay again. Okay. Okay. Now, let us go to Article 1242. Payment made in good faith to any person in possession of the credit shall release the debtor. Okay. 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 Payment made in good faith to any person in possession of the credit shall release the debtor. No? Article 1242, in this is the law intends to protect the debtor from being required to double payment to the creditor. This is self-explanatory. I will leave this to you. Let us go to 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to obtain the debt shall not be valid. Okay. Let me pause here for a while, class. Okay. Okay. Let us resume recording. Let me share my screen again with you. Okay. We're still on Article 1243. Okay. Sorry about the interruption. Okay, let us proceed again. Now, payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. This is self-explanatory. I leave this to you. Okay, 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than that which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another or forbearance against the obligee's will. Now, 1244 is self-explanatory. It just means that the obligor is bound to perform the very prestation due, and that must be complied with. Okay? And that the creditor or obligee may not be compelled to receive something which has not been agreed upon. Okay? Okay. Okay. Now, Article 1245 is a very important provision of law. It states that Dation or Dation in payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law on sales. Class, remember this Dation in payment or Dation and Pago. This is a very important provision. Now, Dation and Pago, class, is a special form of payment. No, it is a special form of payment. Now, why is it considered by law as a special form of payment? Dation or Dation in payment is a conveyance of ownership of a thing as an accepted equivalent. No? It is a special form of payment because it is not an ordinary way of extinguishment of an obligation. In Dation in payment or Dation and Pago, what is used as payment is not money but property, which is why it states there that it is a conveyance, it is a transfer of ownership of a thing as an accepted equivalent of payment. No? Application of payment. Now we go to the special forms of payment. Number one, Dation in payment or Dation in pago. And then you have your application of payment, payment by session, tender of payment, and consignation. Now, these are governed by the law on sales because Dation is considered as a species of sale where debt becomes the price of the thing alienated. Okay, we will go into details as we go along. Now, there is Dation in payment when the property is alienated to the creditor in satisfaction of his debt. Now, remember class that in Dashon and Pago, what is to be paid or to be alienated instead of payment of money, the debtor or obligor will surrender, will transfer, will convey ownership over a property in favor of the creditor, and that alienation of ownership of a property is the special payment mentioned in the discussion. No? There is Dashon and Pago when the property is alienated, then that property takes the place of payment. No? Okay. Now we go to Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing, whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Article 1246 class pertains to the quality of the thing to be delivered. It states here that the creditor cannot compel the debtor to deliver a superior quality, while the debtor cannot compel the creditor to deliver an inferior quality. So, in other words, it is only the average quality. No? Okay. Okay. It's self-explanatory. We jump to Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. Now, who will pay for the expenses required by the payment? It is for the account of the debtor. The debtor will have to pay for expenses out of court which is required when collecting the debt. Now, take note, class, that this article does not apply to expenses incurred by the creditor in going to the debtor's domicile to collect. So, for example, can the debtor be held liable for payment of the fare or the gas allowance of the creditor? No. 1247 applies to expenses other than what? The transportation expenses incurred by the creditor. No. So it applies to expenses required by the payment. Now, extrajudicial expenses shall be for the account of the debtor. Okay, that is very straightforward. And then in judicial costs, when you say judicial cost, this is the expenses incurred in case that a party is compelled to file a case in court in order to enforce the obligation. Now, the losing party, as a general rule, pays the cost of suit. No? Statutory amounts allowed in expense incurred, but this is awarded by the court depending upon the discretion of the court. No? Okay. Now we go to Article 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, When the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Now, this provision contemplates one creditor and debtor. There should be a complete performance of prestation for the obligation to be extinguished, and that the creditor can accept the partial performance but cannot be compelled, meaning it is voluntary on his part. Okay. Now, when is partial performance is allowed? When there is an express stipulation. Number two, when the debt is liquidated and unliquidated, meaning it is partly liquidated and partly unliquidated. Now, prestation of obligation have different terms of conditions which affect some of them. Prestations cannot be executed simultaneously but should be complete. Okay? That is self-explanatory. We jump to Article 1249. The payment of debts in money shall be made in the currency stipulated. If it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. The delivery of promissory notes payable to order or bills of exchange and or other mercantile documents shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in abeyance. So 1249 class provides for the kind of currency which is to be used in terms of payment. In case of default or in case that the parties did not agree on the currency, that it can only be paid in the legal tender in the Philippines, which is Philippine peso. That is our currency. But the parties may stipulate on a different currency depending upon the agreement between the parties. Okay. Now, for example, if you have used some negotiable instruments or mercantile documents, which is the subject of another or the topic of another subject rather, a promissory note class or a bill of exchange, for example, a check. Now, an other mercantile document will only produce the effect of payment after they have been cashed or through the fault of the creditor they have been impaired. Okay. Now, when you say legal tender, this is the payment where the creditor may refuse to accept. Now, the creditor cannot refuse to accept payment if the payment is made in a legal tender. Now, the currency offered by the debtor in the right amount, the creditor must accept. Okay? Okay. Now, take note, class, of the central bank circular, no? O the Bank Sentral ng Pilipinas. No? Meron tayong legal tender depending upon the amount. So this is New Central Bank Circular number 537 series of 2006. Okay? Coins shall be legal tender in amounts not exceeding to 1,000 pesos for denominations of 1 peso and above. Which means, class, that if you will be paying for using 1 peso or 5 peso coin or 10 peso coin, then you can only pay up to 1,000. Imagine, class, if you will be paying in the amount of 1 million pesos using 1 peso coin, then it's going to be a tremendous problem on the part of the creditor. Because how can he keep the thing? Or it's going to entail a lot of logistical problems in terms of counting the 1 peso coin. So under Central Bank Circular 537, if you're going to use a coin as payment, 1 peso and above, meaning 1 peso coin, 5 peso coin, 10 peso coin, it is only valid up to 1,000 pesos. Amounts not exceeding 100 pesos for denominations 25 centavos or less. Okay. Article 1249, payment by means of instrument of credit. So, okay, you have here negotiable instruments are checks, promissory note, Payable to order or bills of exchange are not considered as legal tender. Take note of this, class, huh? Check are not or checks are not legal tender. Promissory note is not a legal tender. That means that the creditor can refuse to accept it. No? Now, right of creditor to refuse or accept. Okay? Again, take note that these mercantile documents, a promissory note or a check or a bill of exchange, can produce the effect of payment. It will extinguish the obligation unless only if they have been cashed or impaired by the fault of the creditor. We go to Article 1250. In case of extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. The 1250 class talks about extraordinary inflation or deflation. Inflation is the rising of prices, while deflation is the sudden drop of deflation. Now, if the currency suddenly drops or inflates, no, then the payment will be made, no, at the value of payment or the value of the currency at the time of the establishment of the obligation, and not at the time of payment will will be valid. So in other words, class, for example, if the obligation has been constituted 5 years ago, and then after 5 years there was a sudden inflation or extraordinary inflation, no, or the prices would shoot up, then the value of the currency must be that at the time of the establishment of the obligation. Okay. Okay. We go to Article 1251. Payment shall be made in the place designated in the obligation. This, I think this is very self-explanatory. I leave this to you. Okay. Okay. So this ends our discussion. I'll see you again next meeting. Thank you for listening.